Zuma laid a criminal charge against advocate Downer in October last year and launched a private prosecution last month after the National Prosecuting Authority formally confirmed that it was declining to prosecute Downer. In terms of the Act, a private person has to prove a substantial and particular interest arising from an injury suffered due to the crime in order to launch a private prosecution.
By creating a situation where private individuals is entitled to prosecute in their own name, despite the fact that the state might decide to decline prosecution, exactly gives that, let's call it then, outburst, or that situation where they can get the opportunity, regardless of the initial decline by the state, to have their day in court. And that prohibits taking the law into your own hands.
But private prosecutions are generally regarded as weak cases, says Dr Curlewis. This is because the prosecuting authority uses a low benchmark for a decision at face value whether the accused has a case to answer.
Whenever a private prosecutor wants to do the job of the state on their behalf, then the courts usually frown upon it because it looks like personal vendetta. So you must then show to the court that you have an eagerness, a willingness and a readiness to see it end out.
And that also means that one has to put one's money where one's mouth is. The private prosecutor has to cover the legal fees of the accused up front. Advocate Downer has asked for R1 million.
Yes, that is exactly the purpose of that deposit, to facilitate and pay for the legal expenses, all the legal expenses of the defence legal team on the assumption that an acquittal follows.
Dr Curlewis says the state can also take over the prosecution if during the course of the trial it becomes apparent that a successful prosecution is possible. Renee Heine, SABC News, Durban.